Judges of the court.
Hear ye, hear ye, hear ye. All persons having any business before this.
There's going to be lifelong and permanent, but not quantifiable. So,
Thank you, Mr.
thank you
Harlan.
very much.
Pludeman against Northern Leasing Systems. Mr. Scoff?
Yes, Your Honor. If it please the court, my name is Abraham Scoff and I represent the defendants. I would like to reserve 4 minutes
Certainly.
for rebuttal. The Appellate Division held that the requirements of CPLR 3016B were met as to the individual defendants because, quote, one can readily deduce, given the corporate positions and titles of the individual defendants, that these individuals actually operate the day-to-day business of the corporate defendant and consequently were involved in or knew about the alleged fraudulent concealment of most of the lease. As the dissent points out, there were no allegations directed to any of the individual defendants. Specifically, they were all lumped in with the defendants as a group, and that therefore, no matter how many officers, no matter how many employees actually are involved in running the defendant, the same argument, the same allegations could be made as to all of the officers.
Would it have been enough?
I'm sorry.
Would it have been enough if they had alleged some responsibilities of some of these people and said so-and-so is in charge of the Department of ABC, which was responsible for drafting the lease? Would that have been enough if they'd given some responsibilities for these individuals that were related somehow?
Certainly what was alleged was not enough.
I'm asking, yeah.
They would have had to allege more if the gravamen of the plaintiff's claim is that the lease itself is a fraud and they had, for example, named the general counsel of the company and alleged that he actually drafted or he supervised the drafting or that he was involved in the drafting or enforcement.
If they don't know who did that, why can't they make some general allegations and then allow discovery to proceed so that there is some disclosure as to who did what in the firm? Yeah. And then, where suitable, there could be motions to dismiss.
Well, there are two answers to that in this particular case. First of all, they didn't allege, as the dissent below pointed out, they didn't allege specific conduct as to any of the individual defendants. It's not a case like in Jared where they allege conduct by individual defendants and they're not sure which of the defendants did one thing or another. Instead, they say this is a massive fraud. Top-level management must have known because they are top-level management.
Well, they say to facilitate the scheme, the defendants drafted the lease and guaranteed so that the class members would have to sign on the first page and not know about the remaining pages, and defendants were well aware of this routine concealment. What's lacking there?
Well, what's lacking there, and it was part of the answer to Judge Grafeo's question, first of all, there are many self-contradictory allegations in the pleadings, which when you compare the original verified complaint to what we now have, which is the first non-verified, the first amended complaint, you see that many of the things they've alleged as to the defendants as a whole are implausible that every one of these defendants was involved. That's number one.
That doesn't quite answer the question, though. The allegation, as I understand it now, is just as Judge Kaye read it, which is that this wasn't a question of this generalized fraud where they're going out and getting these things signed up, but that somebody drafted the lease, and then farther on it says defendants were aware that the representatives of the salesman routinely did not give a copy of the lease. In other words, there are specific things that are stated in here, whether they're contradictory to a former, a future, past complaint or not is irrelevant, that says somebody did these. And as Judge Grafeo is saying, why can't we wait at least until bill of particulars or interrogatories to determine, who's in and who's out.
Well, to answer the second part of your question, Your Honor, in fact, this court can take notice of the court file below and not only note that this is the first amended complaint.
No, I want you to get away from that for a little bit. I just want you to assume that the paragraphs 22, 24, 33, 154 say what they say. And what they say is what we've just said they say. Now, if that's the complaint, is that enough in your view to at least go to discovery with respect to individual corporate officers who may have engaged in these claims of having drafted the lease, of having sent the salesman out without giving them instructions, et cetera?
If you allege those 4 paragraphs together with respect to an officer such as the general counsel, who on its face appears to have been involved in doing those things, and you did not also allege that the person you were suing was in charge of the information technology system, then yes, I think they would be. And the second, if I could just answer the second part of his question, the other point that the court should take notice of is that by order of September 06, which is in the court below, discovery actually ended in December 06, and the CPLR, as you are aware, in, for example, 3025A, encourages parties to eliminate motions like this one, which come all the way up to the Court of Appeals, by amending their pleadings to add the information that they find in discovery. We're very far down the road here.
Are you conceding that they've adequately alleged that the document is a fraud on its face?
No, Your Honor.
I mean, if your company were in fact using a document that on its face was fraudulent, that anyone could look at it and say only a crook would use this document, wouldn't you think it's reasonable to think the CEO knew about it? This is your standard form lease?
I don't know if it's reasonable to assume that the CEO knew about it. I think, as the dissent in the first department said, that would depend on how large the corporation was and what the responsibilities of the CEO were as opposed to somebody else. And we're left guessing at those things. And the lease itself, one copy of which is at page 103 of the record, if you just look at it, what counsel constantly characterizes as microprint, you look at the bottom left-hand corner of the first page, says page 1 of 4 in type, which is the same size as the rest
Were
of
all of these lessees, though, given all 4 pages by the sales reps who got their signatures?
First of all, the document itself
Is that a yes or no?
Yes, the document itself is actually 1 page. It's a booklet.
So their allegation is not correct that they only received the cover page?
Their allegation is not correct that they only had the cover page in front of them. I do not know whether each lessee actually received a copy.
And that raises another question. That was my question. Did the sales rep give each lessee all 4 pages of the contract after they signed it?
And the answer to that question is, our employees were not even present. We wouldn't know one way or the other.
But it is sufficiently alleged that the answer to Judge Graffio's question is no, isn't it? I mean, they allege they never got it. The sales representatives did not give them a copy.
They allege that at least some of the plaintiffs who dealt with sales representatives did not get a copy. That's correct.
Your point is they weren't your sales representatives. They were working for the equipment supplier.
That's correct, Your Honor. And that's in the record.
And I guess your posture was they were supposed to write or call somebody to get a copy of the contract?
Well, in fact, if they wanted to get a copy of the lease from us, as opposed to the equipment supplier, they could call or go on the Internet and get a copy. It was not our posture that they not be given one by the equipment supplier.
But they're alleging that it was. So you may have a very good defense to this claim, but we're not at that juncture. And they are alleging that it was a scheme, a fraudulent scheme perpetrated by the defendants, your corporate and individual clients. That's what the complaint says.
Your Honor, if you put yourself in the position of, let's say, Defendant Bernadone, who's alleged to be the Vice President for Information Technology of the company, when he looks at this document, he runs the computer systems for the company. When he looks at this document and says, why is it that I'm accused of a fraud and I'm a defendant in a putative class action where thousands of people are suing me, if he looks at the appellate division's decision, it says, well, based on your title as Vice President of Information Technology, we can deduce that you knew about this fraud.
No, that's not so. They go on to make particular allegations here. I'm looking at them.
Okay, well, some of the particular allegations, for example, which we run through at pages 6 and 7 of our brief in a footnote, they make allegations against all of the defendants.
And each of them.
Well, no, all of them, in a generalized fashion. And some of these allegations, by the nature of the allegations, they are clearly contradicted by other documents, not that we put in, but that the plaintiff itself put in.
It sounds like you might have a very good defense in this case.
Well, it's more than that. This court has often looked at the entire record on a motion like this, both to fill in holes in a plaintiff's pleading on the one hand.
Suppose they alleged.
And also to discredit things that the plaintiff has alleged on the other. I'm sorry, Your Honor.
Suppose they alleged that they alleged that a particular person, a named defendant, had written this document with his own hand. Would that be a sufficient claim?
If they allege that a particular defendant had written that with his own hand, and that document in and of itself is not a UCC 2A lease, but a fraud.
Okay. I guess I'm wondering why you seem to skip over that second point. I mean, to me, I could understand that if your company were sending out a document that smelled, I could understand why you would say maybe maybe we can infer the senior officers are involved. I'm having trouble detecting the odor, and I'm wondering why you seem not to argue that point. I mean, why is this not just an innocuous piece of paper?
I was trying to argue that point a moment ago when I pulled out the lease itself. The lease itself, I think the court would find to be a fairly standard equipment lease under UCC 2A. I note that the respondent, the plaintiff, in their brief on about the first page referenced some lease comp company which we have no affiliation with and apparently mistreated some of its customers, but then when we went and did a search for this lease comp company, it turns out that the most recent case involving lease comp said that the lease comp lease was also an acceptable Article 2A
Have you moved to
lease.
dismiss the complaint?
Not recently. Discovery is completed and there's a motion for class certification pending. This appeal on this matter wound through the court and took a period of time. So I don't remember if we moved to dismiss at the very beginning of the case. I believe we did, Your Honor. Certain of the claims clearly were dismissed as part of this motion. You
don't allude to the UCC in any of your papers. But that aside, at a 3211 stage, you talk about, for example, the defendant Bernadone. I guess he's the ITT guy.
Correct, Your Honor.
Why wouldn't he file an affidavit saying what you just said? That I'm this officer, that I have I do not participate in preparing any leases. I don't have anything to do with salesmen. I don't have any, with respect to all the allegations in this complaint, none of them touch me, and therefore I think that, that on its face it should be dismissed.
Well, Your Honor, perhaps the affidavit didn't cover all the points, but the reply affidavit of Sarah Krieger, which is found at page 244 of the record, describes what the defendant Northern Leasing does and describes some of the things I've just been talking about.
She's vice president operations, correct?
Correct, Your Honor.
Is it reasonable to infer that she knows what's in this lease?
Well, it's reasonable for... Another document on file below indicates there are actually 150 different lease forms of which fall into about 11 different categories. It's reasonable to infer that in general terms, she who is an operations person and who didn't draft the lease knows that under the lease, you charge certain items for certain different things. It would not be reasonable to assume that she understands the legal implications of all the paragraphs because that's not really part of her job.
Thank you, Mr. Scott. You have your rebuttal time. Mr. Chittur?
Good afternoon, Judge.
Good afternoon.
Let me begin by emphasizing one part which they have not touched at all, and that is the appellate division unanimously held. They reinstated the breach of contract claim, and they unanimously held that the pleading stated a cause of action for punitive damages on the contract claim, not just on the fraud claim. Now let's take this to the logical conclusion, Judge. What does that mean? For present purposes, that issue is not before the court. Whether punitive damages are properly stated or not is not before the court. So for present purposes, let's see where this takes us. That means basically the appellate division looked at everything, not just the complaint, but all these 12 affidavits from people all over the country, all the way from Connecticut to California, from Washington to Florida. Everybody telling the same story. This is exactly what happened to us.
Isn't it the essence of your claim that this was an attempt to conceal pages 2, 3, 4 from your clients?
That is a major portion, not the entire one. That is a major portion, yes.
But if you're, especially if you're trying to get the individual officers into the case, isn't it quite important for you to have a document that presumably originated with the company? I mean, you can't say that every officer knew everything every salesperson who wasn't even their employee said to your clients.
We're not saying that, Judge. What we are saying is quite simply that this fraud, this was the central business of the company. This is not peripheral. This is the central business of the company.
I see that point. I guess what I'm leading up to is what's so terrible about this lease? I mean, what is there on pages 2, 3, and 4 that is supposed to have sent your people into shock if they'd known it?
Well, let's begin with one point, Judge. This is the classic fraud where you take $5 for every month from 300,000 people. That's how many leases they had 3 years ago. You're talking $1.5 million a month. Okay? Nowhere in the lease. You look at the lease. The first page of the lease has got explicit in bold a column that says schedule of payments. It says first month payment, last month payment. Look at Mr. Hansek's lease. First month payment is $32, last month's payment $32. Now, in addition to that, they tack on a whole pile of stuff, and one of them...
Where on pages 2, 3, 4 do they tack on more payments?
They don't tack that on. That's the best part of it, Judge. The lease, none of the 4 leases that has come before the court.
You're saying it's not on... this is what's bothering me. The things you're complaining about are not only not on page 1, they're not on page 2, they're not on page 3, they're not on page 4.
It is conceded, Judge. They have said it themselves. They charge $4.95 per month to every single lessee.
I guess this is what's bothering me. I read this as that it's a very basic part of your claim, that they concealed pages 2, 3, and 4.
Correct.
I'm asking you, what is it that they were hiding, and you haven't told me yet.
The charge, let's take this one item, Judge, LDW charge. The loss damage...
And on which page is that?
Okay. As a matter of fact, it is not expressly disclosed anywhere. Look at page 3, what they have...
Then why are you alleging that they were fraudulently prevented from reading the later pages when you now tell me there's nothing in there about it anyway? I mean, if it's not in the contract... then your problem isn't fraud, your problem is you don't owe them money.
No. If Your Honor will just bear with me for 2 minutes, okay? Here is the lease concerning Hansik audio, one of them. If Your Honor will take a look at this clause 8, this is what they have claimed as authority for levying this $4.95 per month on every one of the lessees.
Okay, but...
I'm sorry, which provision is that?
This was in page 3, Section 8, insurance.
Looks like a pretty typical lessee shall insure the equipment clause.
Well, except that number 1, the lessee didn't know about it, and number 2, you can read this 15 times, it doesn't tell you $4.95 is the charge we will levy.
Well, your claim on the insurance is, if I understand this particular clause, is that the lessee agrees to get insurance, and if you don't, they will get it for you and charge you for it. And of course, you're saying that because you never saw page 3, you didn't know you were supposed to get insurance. They then went and got it for you for this price, and it's added on to the cost.
Correct. I didn't even know that I was supposed to get insurance.
What's another example?
I'm sorry?
What's another example?
The lease is literally eternal, Judge. It keeps automatically renewing. So you have Mr. Hansek who signed this lease in early 1999.
Which clause is that?
They said that is...
15.
Return of property.
60.
And in fact, there was a letter they sent to Pludeman, which is also there in the record, where they say, by the way, you should know that, this lease is automatically renewing. And incidentally, he's the only one that got the letter. Now the question...
What is the language you rely on that says automatic renewal?
We are not relying on any language, Judge. They just continue.
No, you may be...
They just continue forever.
Mr. Chittur, you may be relying upon Section 15 buyout option, which says the exercise of this option, which is to terminate, must be communicated to the lessor in writing at least 60 days prior to the expiration of the lease term. Mm-hmm. And if you don't, then the lease is going to continue, correct?
Yes, Your Honor could say that. But the fact is, Judge, none of these people all the way from, Connecticut to California, as I said, none of them knew about this at all.
Right. And
Now,
one of your
Mr.
other
Hansack, I'm sorry.
One of your other arguments is that they didn't know that New York was going to be the forum for any disputes.
Exactly,
Even
Judge.
though they're in Mississippi and
You
Texas.
you have this highly deceptive document that is sold to, Cambodian refugees running nail salons in Biloxi, Mississippi. They don't even know what it is.
Yeah, but the
next thing they know, they're saddled with a lawsuit in New York City Civil Court for $3,000 and say, look, it's going to cost you more to settle this than it is going to cost you to litigate.
The automatic renewal clause, as I read it, says this automatically renews if you don't return the equipment at the end of the lease. What did your clients think was going to happen if they didn't return the equipment at the end of the lease?
Judge, each of the cases, none of these people knew that they were supposed to return, number one. None of these people knew that in the beginning.
Well, they knew they were leasing the equipment for 4 years. Did they think they're going to keep it?
Well, if it doesn't say in the laws, you're not talking IBM and McDonald's here, Judge. You're talking about ma and pa stores, small people in all over the country, in the interior, most rural parts of the country.
Well,
this is not sophisticated Wall Street lawyers.
Part of your claim is that even if they thought, I'm coming to the end of the lease and I'm going to turn this in, if they didn't do it at least 60 days prior to the expiration, it was too late for them to turn it in at the end of the lease. Isn't that also part of your complaint?
That is also part of the problem, Judge.
And another part, as I understand it, was you're saying that the equipment is purchased for about $300, and if you add up the 48 months of lease here, that's roughly $4,800 that they're paying for a $300 piece of equipment.
That's correct, Judge. I mean, that by itself, might not state a legal claim, but just by itself. But if you look at the whole scheme, that's the way this whole thing is run. That you have this $200 equipment, and it's being leased for $42 a piece for 4 years ahead, and then they keep on and on. I mean, Hansack signs this lease in early 1999. 2004, he's looking, this bank deduction is still going on.
I guess I understand the point that your clients are not sophisticated people and that this may have been an onerous lease. Is that really a fraud claim? That is, are you really saying that if the Cambodian refugees you describe had been handed a copy of this, they would have said, oh no, I'm not signing, oh no, I've just read paragraph 15 on the back, I'm not signing this? Is that really what went on?
No, that's a different story, Judge. That is with respect to the conduct.
Isn't that the essence of a fraud claim?
The essence of the fraud claim is basically what Your Honor pointed out, the order in the lease on the face of it. Why would you draft a document like this that is on the face of it deceptive? Why do you say here, schedule of payments, first month payment, last month payment, $32? It doesn't say anywhere. Nowhere does it say. Now, if Your Honor were to look at their reply affidavit, they have said it categorically. There is absolutely no dispute. The reply affidavit says that we are charging $4.95 every month to every single lessee. We've been doing it since 1998. Now, what prevented you from putting it up here? Put up $4.95 here per month.
What obligates the lessee to pay it?
The lessee is not obligated, Judge. They just deduct it. That's it. Once you signed it, that's the end of the story. You've lost control. Every month there's an automatic deduction in your bank.
What did they sign that obligated them to pay this $4?
Yeah, in the lease, there is, Your Honor will see in the first page of the lease about your bank. That gives them the bank information and the automatic deduction. And with this automatic deduction, that's it. End of the story.
How did you choose which individual defendants to name?
That's a good question, Judge, because we didn't know. All we knew were the 4 names. These are the only names given in the website. These are the big bosses of the company, period.
So you picked them off the website?
That's correct.
Okay. How do you know they have any connection to the fraud that you're alleging?
Well, this is, as I said, this is central to the business. This is not a story where one salesman went out and said something like this. This is central to the business.
Well, what would be the limiting principle then? Does that mean any time a company is sued for fraud that you just pick off the numbers of some of the executives from the website and assume that it's central to the business?
No. Anytime you have a fraud that is central, which is the mainstay of the business, you can assume that the top manager of the company is responsible. They know.
What about
the mainstay of the business.
What about the gentleman who's in charge of the computers?
We will have to get into that, Judge. But when he is specifically named, if all he was doing was taking care of the software, there was no need for naming him up there. Now, I don't recall exactly what exactly they said he did. But we'll get into that in discovery, Judge. And by the way, discovery is not closed. So, but I'm not going on items reholds the record. Discovery is open right now because the fraud, the contract claim has been reinstated. The point, however, is quite simply this, Judge. Can you claim an immunity for fraud? Is this, in other words, is this 3016 going to be converted into an immunization provision just because you put in a whole bunch of people? I mean, you're sitting on top of the mountain, you throw a boulder down, and the little sparrow sitting down there on top of the,
I can
tree gets hurt.
I can understand how you might have some difficulties, how you would have difficulties before discovery, but you still have to allege something, don't you? Some kind of connection, at least that this would be within the job responsibilities of these individuals before they can be named?
How would the ultimate consumer know the job responsibility of a company that is privately held? In fact, today, if Your Honor goes to the website, even that information is not there. The information that was there 4 years ago when we filed this complaint, even that information is not there in the website.
Well, I guess I can understand why.
Exactly. So there's
I guess
no information out there.
Maybe a number of companies would do that.
Your Honor will say this is the perfect immunization technique. Draw yourself from distance, put in some people in the middle, and then anybody who comes into the fraud claim say, oh, by the way, he hasn't told us the details. No, he doesn't have to tell us the details. The question is, 3016 doesn't say tell us the details.
The detail we're concerned about here is which individuals did it. I mean, assuming there's a fraud here, your position is you don't, obviously, if it's this large a fraud, some senior individuals in the company did it, you don't know which ones. Is it really right to say I'm going to pick out the top ones and accuse them, or shouldn't you, don't the rules require that you sue the company, that you take discovery, and then if you find out who the bad guys are, you can add them?
But the other way around, Judge. If you were to try to do that, they'll turn around and say you're on a fishing expedition, you're not going to give you a discovery. Number one. Number two.
Well, if you bring a fraud case against a company, you would normally find out in legitimate discovery which, if any, of the company officers were at fault, wouldn't you?
Not necessarily, Judge. Not necessarily.
Well,
Secondly,
if you don't, it'd be hard to prove the fraud if you didn't, wouldn't it?
I'm sorry?
It would be hard to prove the fraud if you couldn't find if you couldn't find the fault, couldn't find the individuals at fault. I mean, how would you ever prove your case?
Not necessarily, Judge.
Well, somebody has to commit a fraud.
Yes, but is it enough to bring them forward? That's one thing. See, you also have to look at another angle of this. This fraud has been going on since at least 1999. Okay? Now, this is almost akin to the first Jersey securities fraud, Judge. In 1968, the SEC tried to shut him down. He kept opening up under new companies, new names. So you shut one down, he opens up another name. Why? Because nobody knows exactly what this guy did, so you can't sue him. So he keeps opening and opening and opening until finally in the late 90s, he was nailed in the Southern District of New York by Judge Owen. So the point is, it's an issue of deterrent from a public policy perspective, Judge.
Did you take any depositions of the individual corporate defendants named here?
One of the defendants, yes. And that's a beauty, Judge. One of the judges asked...
Which one?
Sarah Krieger. Okay? She's the one, incidentally, if I may point out, Your Honor, and where this goes all the way to the top. Okay? There was one gentleman from Florida who presented evidence. He presented passport entries, visa entries in his passport, showing that he was not even in the country on the day on which that lease was supposed to have been signed. And they sued him.
What did her deposition reveal about her participation?
Oh, she was very much on top.
I mean,
We know she was on top, but what did she have to do with the fraud?
She was the one, she knew about the leases, she was involved in drafting the leases, she was the one who was doing affidavits to court, and this is the one...
Did she know that the man was not in the country on the day the document was signed?
Oh yeah, and she's given an affidavit. I'll draw Your Honor's attention to that in page 244.
You're saying that at the time, you're saying you can prove that Sarah Krieger knew at the time that this signature was obtained that it was a false signature? You have evidence of that?
No, later that. After that, what happened was this.
You're suing her for fraud.
No, one minute, Judge, if you'll bear with me. I'm suing her for conducting a fraudulent scheme. One of the elements of the scheme is that you are misusing the New York judicial system, okay? And here is one classic example. Here is a guy who went out and they were deducting from his business account every month.
And the signature was not his on the document?
He came to now.
Okay.
He brought it to your attention. He sent you a copy of his passport and visa. What is her response? Her response, she said it under oath. and she said it in the oath before the city court, and she's repeated that before this court. It's page 246, paragraph 15. She says the entries in his passport and visa were not conclusive about his presence in the country. What does that mean?
What, could you humor me for a moment, even though your time is up?
Just a moment.
Could you just walk me through the elements of one misrepresentation that any of these individuals made or is fairly attributable to or even one misrepresentation the company made? A misrepresentation.
I'm glad you asked the question, Judge. The first one, the 495 misrepresentation. If you're charging 495 every month to every single person, don't you have an obligation to put it up here, saying we charge you 495?
I think I've heard that before, Mr. Chittur. Thank you.
Thank you, Judge.
Mr. Scott?
Your Honor, the appellate division reinstated the contract claim as to the corporation only. Discovery as to fraud claims has been closed since December '06. The court below permitted the plaintiffs to take additional discovery on the reinstated contract claim against the corporation. That's all that was reinstated. Secondly, the charges that a lessee would be subject to would be shown on the bills that they got every month. So
no, his point is not that. His point is that this lease looks like a one-page lease because most leases you sign at the bottom. This lease, for some reason, you sign at page 1, even though there's 2, 3, and 4. And he's saying that within the context of the provisions that, according to him, his clients didn't see, there was a provision in there that said you will provide insurance. They didn't know that because they never saw it. The provision then says if you don't provide insurance, we will, and we will charge you for it. And that's what happened. And they didn't know it was going to happen because of the fraud that they're claiming, and that you didn't have to send them bills. All you had to do was deduct it from their bank account, because once you got their bank information, you kept taking money out on a regular basis for things like insurance. That's the claim.
Right, I understand that, but once again, he didn't allege